Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. I had a YouTuber to say that filing the EEOC complaint is a waste of time. And I understand the frustration, but you know what? The EEOC complaint produces information and may produce the best evidence. And what is that best evidence? The employer's position statement. And that's what we're going to talk about today. The position statement and the gold in it. But you got to dig for it. So let's get started. The position statement. An employer's position statement is a response to a charge of discrimination filed by an employee with the Equal Employment Opportunity Commission, or EEOC. It's the employer's opportunity to share their version of the facts and provide evidence, their evidence to support their position. The EEOC reviews the position statement and any supporting documents as part of their investigation before issuing a determination or a right to sue letter. So, how is it gold? Defendant's position is etched in stone. Think about it. The employer has had time to consider and respond to any inquiries propounded to it by the EEOC. The employer has had time to gather information, whether it's interviewing company, employees, witnesses. Remember, facts don't change. Sure, people forget information or could be mistaken about what they said, but overall, the facts don't change, particularly in this scenario where the employer has had ample time to verify its information. Thus, any deviation potentially raises an inference of pretext. And what is pretext? In other words, the articulated reason that the employer gave for the adverse action against the employee, such as terminating the employee, is really not the real reason why the employer terminated the employee. It's to hide discrimination, circumstantial evidence. And three is gold because it sets the stage for discovery and for the plaintiff to map out his or her discovery plan. And the questions and requests that the plaintiff will make to the defendant, whether it's through admissions, interrogatories, production of documents, or depositions, the questions and requests should be tailored around the prima facie elements of the claims or causes of action named in the complaint and around facts from the position statement that raises an inquiry for additional information or certain information to make clarity of a statement in the position statement, or questions that lead to relevant information from facts given in the employer's position statement. Very powerful. So, plaintiff, whether your claim or cause of action is based on discrimination, harassment, hostile work environment, retaliation, it is more than likely that you're going to rely on circumstantial evidence to demonstrate pretext. How many employers, for example, is going to be direct with their discrimination? Now, we are going to look at some cases of circumstantial evidence, but we're also going to look at one that demonstrates direct evidence. Now, in the first case, this is Shager versus Upjohn Company. This is an example of a direct evidence case. Interesting, the court found that the employer terminated the plaintiff, Shager, based on his age. Evidence existed that Shager's supervisor harbored and exhibited hostility and animosity towards older workers. He was heard to say to one of Shager's younger salesmen, "These older people don't much like or much care for us baby boomers, but there isn't much they can do about it." He also was heard to make frequent comments to the effect that the old guys know how to get around things. The court found that Lynch marginalized Shager's outstanding sales performance as a result of animosity for older workers. And the court concluded that Lynch or defendant's termination of plaintiff was motivated and based on his age. The selective enforcement of a disciplinary policy is circumstantial evidence to prove discrimination. In this case, the defendant, Walgreen, terminated the plaintiff. But in terminating the plaintiff, Walgreen deviated from its disciplinary policies. The court found that that amounted to pretext. The court held that an employer's unusual deviation from standard procedures can serve as circumstantial evidence of discrimination. And also, the same evidence can be used in harassment, hostile work environment, and retaliation. False explanations is another way a plaintiff can prove pretext discrimination. In this case, again, it's the same case, Baines versus Walgreen Company. There was evidence that the employer lied about the reasons for an adverse employment action, which the court said permits a trier of fact to infer that the decision was actually motivated by discriminatory animus. The Supreme Court has noted that, this is important, because a fact finder may infer intentional discrimination from an employer's untruthfulness, evidence that calls truthfulness into question. Remember this, precludes a summary judgment. Ambiguous, inconsistent, shifting explanations for termination. Pickett started working for Sheridan Healthcare. It sounds like it's a convalescent hospital. She started out as a dietitian and then she moved on to work as a housekeeper. And she complained to defendant that the residents were groping her. Of course, the male residents were groping her. And listen, as I was reading this story, I kind of went back to the days when I was in high school and I did my internship in a convalescent hospital. And sometimes these old cats can get a little frisky. So I know how Miss Pickett felt. And so she went to Zeller, who was one of the management employees, and complained to him more than once and that nothing had been done. She was getting frustrated. They even accused her or suggested she invited the conduct. One of the management employees even said to her, "Well, you are a pretty girl. What are you doing to make them want to touch you?" Can you imagine that? So she's speaking with Mr. Zeller and complaining that nothing is getting done. And he responds to her, maybe she should go clean some stores. And he also says to her, this is their home, referring to the residents, and nothing is going to change. So Miss Pickett leaves the facility. Mr. Zeller tells Miss Pickett that she was terminated because she walked off the job. But he later told her she was terminated because it was best that they part ways. That, coupled with what he said, plus what the other management employees said, the court said this: shifting explanations for termination and ambiguous statements can support an inference of bad intent and pretext. So, what am I saying? Pro se, when you're reading the defendant's position statement, extract or highlight the pretextual conduct, whether it's employee animosity, selective enforcement of disciplinary policies, false explanations, ambiguous explanations for termination, and there are others, and follow up in discovery. And the next thing I want to talk about is suspicious timing. And this is directly related to retaliation, the fourth prima facie element, causal connection. So we're going back to Baines versus Walgreen. Baines filed her EEOC charge in 2007 and again in 2009. Now, 5 years later, after 2009, Walgreen would not rehire her. Now, one would reasonably come to the conclusion that 5 years is just too much time for there to be a causal connection. But here's what the court said: suspicious timing can provide circumstantial evidence of retaliation, but generally the timing is not suspicious when there is a long gap between the protected activity and the adverse employment action. But here is the caveat: this does not mean that a long gap will undermine a causal connection that is otherwise supported by sufficient circumstantial evidence, as is the case in Baines versus Walgreen. So while a short gap is likely to infer pretext, where the plaintiff complained on June the 3rd and the defendant terminated her 1 week later, that is a strong inference of pretext because of the causal connection. But also, there could be a longer gap, and pretext still could be applicable. That's the point. Supported with circumstantial evidence.